as we have seen that of late, PMLA IBC has evolved like anything. Though tax law was always there, and we always heard about various judgments and precedents. We have been taking sessions on PMLA separately, IBC separately, on tax law separately. But this is a rare occasion that we have taken an interplay between the tax law, PMLA, and IBC. Mr. Vinay Shroff, an advocate in Calcutta High Court, who also practices in Supreme Court of India, has been taking sessions not only on this platform, but across different webinars and seminars. We are glad that he has accepted our invite. Thank you, Vinayji. Despite the fact that it's a Saturday, you acceded to our request. Over to you, Mr. Vinay.
Yeah, thank you, sir. Thank you very much for giving me this opportunity. So, the purpose of this session is that you know that the Prevention of Money Laundering Act was a dormant act till 2016, when substantial amendments were made in the Prevention of Money Laundering Act. The rules were notified and the act was put into motion, even though the substantial amendment prior to 2016 took place in 2012 also. But by and large, the Prevention of Money Laundering Act has become an operative act since last 7-8 years only. Prior to that, there used to be one-off action under the PMLA Act. But now the government is very active. The administrative machinery and the enforcement machinery has also received a boost from the government. And now it has a robust infrastructure, and the action is swift. And simultaneously, the Insolvency and Bankruptcy Code 2016 came into place, where the objective was to resolve or to rehabilitate a company which is financially distressed. At the same time, there is a tax law. So what happens if a company undergoes the liquidation? So whether tax loss can be recovered from a company which is financially distressed and which is in the process of getting reorganized. Now, other question is, if there are tax dues, then whether can simultaneously the action under the PMLA Act also be taken? So all these issues I will deal with. But prior to that, the interplay between the PMLA Act vis-a-vis tax law, the interplay between PMLA and Insolvency and Bankruptcy Code 2016, the interplay between IBC and the taxation laws. I would like to start the session with a brief overview of the PMLA Act. The PMLA Act, which is a 2002 Act, was passed with the twin objective rather. The objective being to confiscate the ill-gotten property, the property which has been gathered through criminal activities, and also to simultaneously punish the criminal under the purview of the PMLA Act, in addition to the prosecution which can be done under any other law, the specific law like the anti-drug law or say Indian Penal Code. So before I delve into the purview of the PMLA Act of the Indian PMLA Act, that is the PMLA Act 2002, I would like to discuss the historical background of the money laundering terminology. So the term money laundering arose in 1920 in the United States when the American police officers, with reference to the ownership and use of laundrettes by the mafia group, gave them means of where the mafia group tried to use the laundries to clean the clothes. They were used to try to give them a legitimate appearance by using the laundries. And therefore the term laundered arose, whereby the money, mostly the drug money, which was earned, or the money from the drug proceeds, the criminals tried to project it as an untainted property by using the laundries. The clothes were not washed, but it was shown as if the money, which was a drug money, has been earned through washing of the clothes. So virtually a dirty money was washed into a clean money by using the laundries. So that is how this word laundered arose, and the term money laundering came into being. And this term money laundering was first used in the legal context in the American judgment of 1992 concerning the confiscation of laundered Colombian drug proceeds. But this particular law of money laundering gained prominence after the Vienna Convention in 2002, sometime around 2002, wherein a need was felt to primarily confiscate the drug trafficking offense. But subsequently, the scope of the offenses kept increasing, and various other crimes and the money earned from various other crimes were also included within the purview of the money laundering. So not only the drug money, but the money you earned through, say, the human trafficking, the money earned through terrorist activities, and various other criminal activities were sought to be confiscated, and the dealing in the money earned through crime was sought to be prohibited. The free flow of the money flowing from one jurisdiction, one sovereign country to another, where the money was sought to be converted from a criminal money to from a untainted money to a untainted money, was sought to be stopped or curbed. Thereafter, in 2010, the Financial Action Task Force, which was created as G7 initiative to develop more effective financial standards and anti-money laundering legislation, stated that not only the generation of the money laundering, the money earned through any of this criminal activity, but the concealment, possession, disposition, or use of the proceeds of crime were also sought to be criminalized. So various other activities subsequent to the generation of the money, whereby the money, somebody is helping in concealment of the money, somebody is helping in possession of the crime money, or the proceeds of crime, as it is called in legal terminology, or disposition or use of the proceeds of crime were sought to be criminalized. And India was also not compliant with the direction of the FATF, and therefore it was asked to remove the deficiency in its law. And the PMLA Act 2012 substantially amended Section 3 of the PMLA Act to include various activities. So I will go into how money laundering is defined in Section 3 of the PMLA Act. But before I do that, I want to give you a perspective into what is the primary objective of the PMLA Act. It is to enable the law enforcement agencies to confiscate the proceeds of criminal activities and also to apprehend the high-level criminals so that they are parallelly prosecuted within the purview of the PMLA Act, apart from being prosecuted within the purview of the respective criminal law. So this act, let me make it again very clear that it not only confiscates the property, so the objective, this PMLA Act is neither a civil law nor a criminal law, but it is a rather amalgamation of the various facets to address the issue of the money laundering. So, in one sense, it is a sui generis legislation because there are multiple objectives which this particular act seeks to address. Now, coming to the question of the magnitude of the money laundering activity across the globe, as per an estimate of the IMF and FATF, it is estimated that 2% to 5% of the global GDP is the money which is generated through the money laundering activity. And as per the estimate of the United Nations, it is something around US dollar 2.1 trillion or 3.6% of the global GDP. So Indian PML Act is merely a cog in the international vacuum to prevent and to comply with the directions of the FATF. Now, coming to the Indian money laundering law, let us have a look at how Section 3 is defined. Vikas ji, kindly allow me screen sharing.
Just hold on. I think otherwise we can post it on the this website. That would become better.
What?
What you want to share on the PPT? I'm saying
No, it is not a PPT. I just want to show the definition of money laundering. Section 3 of the Money Laundering Act.
Meanwhile, you can start. I just changed my set. You continue. I will just see if I can just hold on. Yes.
You just need to change the settings to allow me to share the screen. Screen sharing वाला जो है ना ऑप्शन इनेबल करना है सर. उसमें ऑल कर दीजिए पार्टिसिपेंट्स तो हो जाएगा. So let me continue while this screen sharing is allowed. So the expression money laundering under Section 3 of the PMLA Act, it captures every process or activity in dealing with the proceeds of crime, not only directly, but also indirectly. And it does not mean that it only connects the process of the integration of a tainted property in the formal economy to constitute an act of money laundering. And it is also important to remember that the act of money laundering is an independent offense regarding the process or activity connected with the proceeds of crime. So, with respect to the civil aspect of the confiscation of the property, it is not necessary that the person concerned must be charged with the predicate offense. It is possible to confiscate the money generated through the process of the money laundering if it is used in any process or activity connected with the proceeds of crime. Now, what are those activities? The activity of the concealment, the activity of the possession, the activity of the acquisition, the activity of the use of the proceeds of crime. So, if any person is directly or indirectly involved in any of these processes or activity connected with the proceeds of crime, then it will constitute the process of the offense of money laundering. So, now coming to the question of what is proceeds of crime? The proceeds of crime ये नहीं इनेबल हो पा रहा है क्या विकास जी?
मैं एक बार चेक कर रहा हूँ, बता रहा हूँ। एक मिनट विनय जी, आप करें कंटिन्यू, मैं ट्राई कर रहा हूँ। एक मिनट,
क्या बोल रहा हूँ?
आप ट्राई कर लें, मैं तब आप अपना कंटिन्यू करें, मैं देखता हूँ एक बार स्क्रीन शेयरिंग का अलाउ करता हूँ। आई जस्ट चेंज द सेट, इसका मेरे को बॉटम में दिखता तो वो दिख नहीं रहा।
ठीक है। सो ये क्या है ना, कई चीजें ये दिखाने से ही उसका यूटिलिटी आएगा।
आप कंटिन्यू करें, बस 5-10 मिनट में करवा रहा हूँ, कुछ ना कुछ करता हूँ। विनय जी 1 मिनट कंटिन्यू करें, मैं करवाता हूँ।
ठीक। सो Section 3 says that whosoever directly or indirectly attempts to indulge or knowingly assist or knowingly is a party. So there can be two category of person. One person who directly or indirectly indulges in any activity
ये अमरदास ने वो चैट में डाल दिए, अंबादास।
हाँ, लेकिन वो तो the font size is too small to be viewed.
No, I've made it bigger. Just check it on the screen.
Okay. ठीक है। अंबादास जी, can you kindly also share section 5 and section 2U, the definition of the proceeds of crime? Okay. So whosoever directly or indirectly attempts to indulge or knowingly assists or knowingly is a party or is actually involved in any process or activity connected with the proceeds of crime. So there can be two category of person: the person who is directly or indirectly attempting to indulge, or the second category of person is a person who knowingly assists or knowingly is a party. So the second category of person must be a party who knowingly assists. So suppose I deal with someone who is a criminal and who, सर ये लेकिन आप ये काइंडली इसको शेयरिंग को देखिए इसको, बिकॉज ये जो है ना, देर आर अदर थिंग्स ऑल्सो विच आई विल हैव टू शेयर. सॉरी, ये मैं बंद हो गया. ये शेयरिंग का तो इसमें अलाउ हो जाता है आराम से सेटिंग से.
एक मिनट देखता हूँ, जस्ट होल्ड ऑन. अब आप होस्ट बन गए, कर लें.
क्या बोल रहे हैं?
आपको होस्ट बना दिया, आप होस्ट बन गए हैं. आप कर
हाँ
सकते हैं.
ठीक है, ठीक है, मैं देख लिया, अभी हो जाएगा. यस, विजिबल है अभी. So section 3 says that whosoever directly or indirectly attempts to indulge or knowingly assist or knowingly is a party or is actually involved in any process or activity connected with the proceeds of crime shall be guilty of offense of money laundering. And the explanation says that a person shall be guilty of money laundering if such person is found to have directly or indirectly attempted to indulge or knowingly assisted or knowingly is a party or is actually involved in one or more of the following processes or activity connected with the proceeds of crime, namely concealment or possession or acquisition or use or projecting as untainted property or claiming as untainted property in any manner whatsoever. So if any person, there can be two category of person, as I said. One is the person who is directly indulging in this, in any of these activities. And second category of person who is knowingly assisting the criminal in any of this activity. So the word knowingly is very, very important. And in this context, I would like to mention that when the 2002 Act was in the process of being conceptualized, then the parliamentary committee, the standing committee of finance of 98-99, inserted the word knowingly in the definition of money laundering. Prior to that, it was not there. It was said that the word, it is necessary to insert because otherwise anybody who unwittingly or unknowingly deals with somebody who is a criminal, then he may become liable to the activity of money laundering. So he is not aware of that he is dealing with a criminal, he may be prosecuted with the purview of section 3. So the word knowingly is very, very important. Now, coming to the definition of the proceeds of crime, what is a proceeds of crime? So now let us have a look at section 2U. So section 2U says that the proceeds of crime means any property derived or obtained directly or indirectly by any person as a result of criminal activity relating to a scheduled offense. So the proceeds of crime says that it must be a property derived or obtained directly or indirectly by any person as a result of the criminal activity relating to scheduled offense, or the value of any such property, or where such property is taken or held outside the country, then the property equivalent in value held within the country or abroad. So it is not that the money earned through process of any and every criminal activity will become the proceeds of crime. That particular crime should find a place in the scheduled offense. Now, what is a scheduled offense? It is a schedule appended to the PMLA Act. Now, let us have a look at what are the scheduled offenses. So, as you can see, the various offenses. So, this is a schedule to the Prevention of Money Laundering Act. In Part A, there are various offenses under the Indian Penal Code which are considered as scheduled offenses. For example, criminal conspiracy, waging or attempting to wage war against the government of India, counterfeiting government stamp, sale of counterfeit government stamp, attempt to murder, then kidnapping, extortion, robbery, dacoity, dishonestly receiving stolen property, cheating by impersonation, then forgery of valuable security will, then counterfeiting device or mark. So there are various offenses which are under the Indian Penal Code, which is included. Then offenses under the Narcotics, Drugs and Psychotropic Substances Act, various offenses under that particular NDPS Act has been included. Then the offenses under the Explosive Substance Act, offenses under the Unlawful Activities Prevention Act, then the offenses under the Arms Act, offenses under the Wildlife Protection Act, Prevention of Corruption Act, Explosive Act, Antiquities and Art Treasuries Act. Then there are few offenses under the SEBI Act is also included. For example, prohibition of manipulative and deceptive devices, insider trading, and substantial with acquisition of securities or control. Then offenses under the Customs Act. So as far as the tax law is concerned, the Customs Act only offense under Section 135 is included as a scheduled offense. Then the Bonded Labor System Abolition Act, Child Labor Prohibition and Regulation Act, Immigration Act, Foreigners Act, offenses under copyright, trademark. So I'm just scrolling it down. I'm not reading out everything. Then one more offense is included, that is under the customs law, that is Section 132 offense, that is false declaration and false documents. Then as far as the tax law is concerned, the offense which is included is an offense which is an offense of cross-border implication and is specified in the offense of willful attempt to evade any tax penalty or interest referred to in Section 51 of the Black Money, Undisclosed Foreign Income and Assets and Imposition of Tax Act. So as you can see, the schedule nowhere mentions Income Tax Act or Goods and Services Tax Act or Service Tax Law or Central Excise Law or VAT Law or any other taxation law. Only two sections of the Customs Act and the offense under Section 51 of the Black Money Act is incorporated in the schedule to the PMLA Act. So even if one is prosecuted or held guilty under any of these law, that is GST Act or Income Tax Act, one cannot be held guilty under the PMLA Act. And in this context, I would like to refer to one judgment of the Honorable Supreme Court as well as the extract from the speech of the Finance Minister P. Chidambaram when substantial amendments were made in the PML Act in 2012 to bring it in tune with the recommendation of the FATF. So Honorable Finance Minister said that firstly, we must remember that money laundering is a very technically defined offense. It is not the way we understand money laundering in a colloquial sense. It is a technically defined offense. It postulates that there must be a predicate offense. So predicate offense means schedule offense. And it is dealing with the proceeds of a crime. That is the offense of the money laundering. It is more than simply converting black money into white or white money into black. That is an offense under the Income Tax Act. There must be a crime as defined in the schedule. As a result of that crime, there must be certain proceeds. It could be cash, it could be property. Then he goes on to say that anyone who directly or indirectly indulges or assists or is involved in any process or activity connected with the proceeds of crime and projects it as an untainted property is guilty of offense of money laundering. So it is a very technical offense. That predicate offense are all listed in the schedule. Unless there is a predicate offense, there cannot be an offense of money laundering. Initially, the thinking was unless a person was convicted of predicate offense, you cannot convict of money laundering. But that thinking is evolved now. The Financial Action Task Force has now come around to the view that if the predicate offense has thrown up certain proceeds and you dealt with those proceeds, you could be found guilty of the offense of money laundering. So what we are trying to do is to bring this law on lines of the laws that are commended by FATF, and all countries have obliged to bring their laws on the same line. So what I wish to state is that now there must be first of all, there must be a predicate offense. There must be an offense which has been committed under the schedule. Now one must be charged of that scheduled offense. But anybody, so first of all, there must be generation of the proceeds of crime. And how the proceeds of crime will be said to be generated if there is a registration of the scheduled offense under that particular law. So if any offense is Indian Penal Code, then an FIR must be lodged with respect to that crime with the police. Now, once that is done and the proceeds of crime is identified, now a second person is identified who is not involved in the predicate offense. So he is not charged of the predicate offense, but he is guilty of dealing with that proceeds of crime knowingly in trying to assist in any of the process relating to concealment or use or conversion and or in any of this process. So that person can be charged independently of the prosecution of the person who has committed the predicate offense, who will be prosecuted not only under that respective law, but also under the PMLA Act. But the person who has dealt with the proceeds of crime can be dealt independently, irrespective of the fact that he has not been charged with the predicate offense. So this is something which I wish to make very clear. And therefore, the tax laws, or so to say, the interplay between the PMLA and the taxation laws is limited to the Black Money Act, and a lot of apprehension or confusion is there, and which has arisen because the taxing authority or the PMLA authorities were taking recourse to section 120 capital B of the penal code and saying that it can be independently attracted to attract the provision of the PMLA Act. Section 120B, let us see what section 120B of the Indian Penal Code says. So 120B says that whosoever is a party to criminal conspiracy to commit an offense punishable with death, imprisonment for life, or rigorous imprisonment for a term of 2 years or upwards, shall, where no express provision is made in this code for the punishment of such conspiracy, be punished in such manner as if he had abated such offense. And whosoever is a party to criminal conspiracy other than the criminal conspiracy to commit an offense punishable as aforesaid shall be punished with imprisonment of either description for a term not exceeding 6 months or with fine or both. So what the PMLA authorities were doing, they were invoking 120 capital B and saying that you are part of the criminal conspiracy to commit an offense which is liable for imprisonment for a term exceeding 2 years or upwards. And since there is no express provision made in this particular IPC for that sort of a criminal conspiracy, so you can be brought within the purview of the PML Act. But Supreme Court, in a judgment delivered in 2023 in Pawana Dibur versus Directorate of Enforcement, has held that the offense under section 120 capital B will only become operational if the criminal conspiracy is to commit any of the offenses already included in part A, B, or C of the schedule to the PML Act. So independent of any of the activities which is already included in the schedule to the PML Act, 120B cannot be independently invoked to bring within the purview of the PML Act any tax offense. So if anybody is facing prosecution under the PML Act because of the registration of FIR or because of the initiation of the proceeding by way of a provisional attachment or any such thing, then one must approach the High Court under by a writ petition under Article 226 and get such a proceeding quashed. Now, I am coming to the discussion of, now, as far as the PML Act is concerned, the interplay between PMLA and the taxation laws, one particular reason why the tax practitioners were apprehensive was that the GSTN was brought within the ambit of the GSTN, that is Goods and Service Tax Network, was brought within the ambit of PMLA Act by a notification dated July 7, 2023. But this particular bringing of Goods and Service Tax Network within the purview of section 66 of the PML Act has a very limited purpose. The only purpose of section 66 is to exchange of information between the Goods and Service Tax Network and the Enforcement Directorate. So it enables, if suppose an offense is committed under the Goods and Service Tax Act, then the PMLA authorities may demand information from the GSTN authorities that, look, you provide me the details and let us try to find out if any predicate offense has also been committed, which is a scheduled offense. So that is the limited purpose. But as of now, Goods and Service Tax Act has not been brought within the purview of the scheduled offense. So even if one has committed an offense under the purview of the GST, it does not mean that by virtue of the GSTN, that is the Goods and Service Tax, being brought within the ambit of the section 66 of the PMLA Act, now the offense under the GST Act is also an offense under the PMLA Act. That is not the case. Now coming to the next interplay between the IBC, that is the Insolvency and the Bankruptcy Code, and the PMLA, this is very, very delicate. For the simple reason that both the laws, PMLA as well as the IBC, has a non-obstante clause. While section 238 of the Insolvency and Bankruptcy Code says that it has an override effect over any other law. At the same time, section 71 of the PMLA Act also says so. So the question arises that which law will override the other one. So I think in this case, the law is well settled. The Honorable Supreme Court says that whichever enactment has been brought into force at a later point of time, the non-obstante clause of that particular law will prevail. So here, the IBC Act 2016 was operationalized or brought into force at much later time compared to the PML Act. Therefore, the non-obstante clause of the IBC will prevail over the PML Act. But the controversy does not end over there. Why? Because the very objective of the PML Act is that anybody who has earned the proceeds of crime, that property has to be confiscated and it should not be used by anybody for any purpose. So the question is that even though, suppose, within the purview of the PMLA Act, the property before the insolvency proceedings are initiated. And let me tell you before I discuss this interplay that the Insolvency and Bankruptcy Code, the very purpose is to reorganize or rehabilitate a financially distressed company. And at the same time, in the preamble itself, it says that the purpose of the IBC Code is to maximize the value of asset, promote entrepreneurship, and ensure the availability of credit and balance the interest of the various stakeholders. Whereas the objective of the PML Act is to attach the property involved in the money laundering and to avoid concealment, transfer, or dealing in any manner a property which has been acquired by virtue of money laundering activity or which is a proceeds of crime. So the question is, can a company which has acquired such a proceeds of crime continue? Suppose prior to the insolvency procedure or corporate insolvency CIRP process, which is called corporate insolvency process, CIRP process, is initiated by virtue of section 13 of the Act. If already the property is attached, then what happens to such attached property? So there are two contradictory judgments which I will discuss. But prior to that, let me say that Honorable Supreme Court in the case of Ghanshyam Mishra stated that a successful resolution applicant should start with a clean slate based on the approval plan. Then let us look into two provisions of Insolvency IBC Act, Section 14 prohibits institution of suits or continuation of pending suits or proceedings against the corporate debtor. Corporate debtor means the company against whom the IBC process has been initiated. So if any suit is pending, then it not only prohibits the institution of a new suit, but it also prohibits continuation of the pending suits or proceedings against the corporate debtor, including execution of any judgment, decree, or order in a court of law, tribunal, or any other authority. Further, Section 32 capital A was introduced with effect from 28/12/2019, which provides protection to the corporate debtor and its assets from a penal action for any offense committed under any law, including PMLA. So Section 32 capital A shields the corporate debtor from post-resolution action. So once resolution plan has been approved, then the Section 32A protects the corporate debtor from the criminal action, as well as it says that the property cannot be confiscated under any law. But at the same time, it carves out an exception for liability of the erstwhile promoter and director who were involved in the offenses under the PMLA. So it balances out the interest of the corporate debtor. So the purpose of the 32A is that the new company under the new management starts on a clean slate. Neither its assets are recovered by any other law enforcement agency, including PMLA, nor the new management has to face the criminal action for the criminal activities committed by the erstwhile management. Now, in this context, there is a judgment of the NCLT, that is Appellate Authority of the NCLT under the IBC Act. And I am more in agreement with the line of the thinking of NCLT than one contradictory judgment, which I will also discuss, of the Delhi High Court. The NCLT judgment in the case of Directorate of Enforcement versus the Manoj Kumar Agarwal, it is a judgment dated 9th of April 2021. It says that the aims and object of IBC is maximization of the value of the assets. And if the above act has to be performed, then there should not be any obstructions of attachment or seizure by any authority. If the property is under attachment or seizure, then keeping the corporate debtor as a going concern would be a serious issue. Without the property in possession of the resolution professional, getting the valuation done during the CIRP process or even at the liquidation stage would be issue. So it says that if the property is in attachment with the PMLA, then the valuation of the company will be hampered, because nobody would like to buy a property which is attached by the PMLA authority, whatever Section 32A may say. And the people are unlikely to respond in a positive manner if the property remains attached. So therefore, the property of the corporate debtor should be protected whether or not the resolution plan is passed while the CIRP process is undergoing, to enable the maximization of the value of the corporate debtor. It further says that the aim and object of PMLA under Section 5 of the PMLA Act is to avoid concealment, transfer, or dealing in any manner of a property which may result in frustrating any confiscation under PMLA Act. For the provisional attachment, and Section 14 of the IBC also places a moratorium on transferring, encumbering, alienating, or disposing of by the corporate debtor while the CIRP process is going on. So it says that the purpose and objective of Section 5 and Section 14 are aligned. So no useful purpose will be served if the property remains attached by PMLA authorities. But the Delhi High Court says that there is no conflict, because ultimately under Section 32A, once the resolution plan is approved, then the property will have to be distributed in terms of the waterfall mechanism, and those who are the creditors will have an overriding interest over the attachment by the PMLA authorities. And if anything is left after they're distributing to all the creditors, including the secured creditors, only then the PMLA authorities will get anything. So in their view, there is no problem if the property remains attached while the CRRP process is going on, because till the time the resolution plan is approved, the immunity of Section 32 capital A does not start. It is only after the resolution plan is approved under Section 32 capital A that the immunity comes into play. Therefore, while the CRP process is going on, it does not affect the corporate debtor if the property remains attached. So this is how these two judgment deals with it. But I am more, in my personal view, the judgment of the Honorable NCLAT in the case of Director of Enforcement versus Manoj Kumar Agarwal is more correct. But that will be resolved by the Honorable Supreme Court, as the Honorable Supreme Court has taken cognizance of this particular issue in the case of Ashok Kumar Seraugi versus Enforcement Directorate. Now coming to the last issue which I wish to discuss is the interplay between the Goods and Service Tax or the taxation laws or the Income Tax Act and the insolvency law. Now Section 238 of the IBC clearly says that it will have an overriding effect of any other law. Now in this context, Honorable Supreme Court in the case of Principal Commissioner of Income Tax versus Monet Ispat and Energy Limited has held that the IBC code will have overriding effect over anything inconsistent, including the Income Tax Act 1961. Further, the Supreme Court in the case of Ghanshyam Mishra and Sons Private Limited versus Edelweiss Asset Reconstruction Company, it was held that the mischief which was noticed prior to the amendment of Section 31 of the IB Code was that though the legislative intent was to extinguish all such debts owed to the central government, any state government or any local authority, including the tax authorities, once the approval was granted to the resolution plan, there was an ambiguity. So it says that the central government, state government or any other local authority to whom any debt is owed will come within the ambit of a personal creditor, and consequently a person to whom a debt is owed will be treated only as a creditor, that to an unsecured creditor, and therefore it was held that once the resolution plan is approved within the purview of the PMLA Act, all debts will be frozen, and on the date of the resolution plan, all such claims which are not part of the resolution plan shall stand extinguished, and no person will be entitled to initiate or continue any proceeding in respect of a claim which is not a part of the resolution plan. Therefore, all dues, including the statutory dues owed to the central government, state government, or any local authority, if it is not a part of the resolution plan, shall stand extinguished, and no proceeding in respect of such dues for the period prior to the date on which the adjudicating authority grants it approval under section 31 can be continued. So all dues prior to the initiation of the insolvency process, to the extent it is approved in the resolution plan, will be extinguished. And in fact, no proceeding, whether criminal, civil, anything, once that stamp of approval by the NCLT is given to the resolution plan, nothing can be continued. So with this, I would like to summarize that as far as the interplay between the IBC and the PMLA is concerned, the connection is limited, as only the Black Money Act is covered within the purview of the scheduled offense under the PMLA Act. And it is essential that for a proceeds of crime, it must, the proceeds must be generated out of a activity or offense which is included in the scheduled offense to the PMLA Act. Other offenses, for example, the conversion of black money into white or white into black, even though it is an offense under the Income Tax Act, it may be an offense under the GST Act, but it will not be an offense under the IBC, the PMLA Act. Secondly, as far as the interplay between IBC and the PMLA is concerned, my personal view is, even though there are conflicting judgments on this particular issue, my personal view is that once the IBC process is initiated, the CIRP process is initiated, then all assets should be unencumbered and it should be available to the disposal of the company which is undergoing such process, so that it can start on a clean slate. And the objective of the IBC code, which is to rehabilitate and revive the company which is financially distressed, is achieved. And IBC code has come into force in later point of time to PMLA Act. Therefore, IBC 2016 will prevail. And lastly, if any liability on adoption of the resolution plan is extinguished under the IBC code, then no further recovery under any of the tax laws be made. So with this, I conclude my today's session. Thank you very much. Oh, 1 second.
You have become the king. Yeah. We have few questions. It says, would the proceedings of the TP before the tribunal abate, or should the proceedings go ahead? This is, no.
Yes, sir. I could not get it.
That question was not very clear. So thank you, Vinity. I just saw there's no questions as such. We are glad that you have shared your knowledge. Thank you to all the participants who have watched these webinars. Those who have missed it, they can subscribe to the channel. And your comments on the chat box of the YouTube would be much appreciated. Thank you, everyone. Stay safe, stay blessed. And tomorrow we will be having a session at 6 p.m. Do stay connected with us. Thank you.
Thank you, sir. Thank you very much.